Okay, good evening. Judging by the various Apple products that I have arranged around me, it's now 7:30, so we'll go ahead and start the meeting. So I'd like to welcome everyone to this meeting of the Village of Skokie Zoning Board of Appeals. The Zoning Board of Appeals is created by the statutes of the state of Illinois and by the ordinances of the Village of Skokie for a purpose of granting proper case relief from the strict terms of our zoning ordinances. The decision of this board to either uphold and concur or reverse the finding of the zoning official will be based upon the record and reports issued. The Zoning Board of Appeals is not a court of law, and therefore we do not take testimony or follow the strict rules of evidence. However, this hearing will be conducted in such a manner as to hear only competent arguments. Questions as to procedure, interpretation, and of the admissibility of statements or evidence will be rolled upon by Corporation Counsel Tyler Kabilski, and his legal decision will be binding upon this board. So before we proceed with our case tonight, 2018-02Z, I'll ask Corporation Counsel, has proper notice been served?
Notice was properly posted and is correct.
Okay, thank you very much. And before we move forward with the case tonight, just a little house cleaning to do, and that's to approve the minutes from our prior meeting of February 21st, 2018, which was a case at 2018-01Z, 3609 and 3639 Howard Street. I'm sure everybody on the board has had a chance to review the notes, and if everybody is in agreement with the notes, the chair will entertain a motion to approve the minutes.
So moved.
Okay.
Second.
All right, Commissioner Gersner. Commissioner Franklin seconds. Voice vote, all, please?
Yes.
Yes? Okay. Anybody opposed? No? Okay. I would thank Marlene, but she's not here tonight. So. Okay. All right, now that we've had that taken care of, I'll let Corporation Counsel Tyler Kobilski proceed with the meeting tonight.
Sure, I'll just say for the record that this is going to be a little bit more unusual than we've encountered in the past. This is the first instance where we're being asked to review the interpretation of a zoning official. So it's going to be different than you're normally accustomed to. Essentially, it's going to be broken up into argument from the petitioner, argument from the Corporation Counsel's office, and then a short rebuttal. There is no testimony that's going to be offered in this case. There's not going to be any new evidence that's going to be offered in this case. You're really to base your decision on the evidence and the facts gathered by Brian. We came to the decision he came to, as well as a submission from the counsel for the petitioners, as well as a staff report that's part of the record as well. We do have a court reporter present, so I would try to have everyone wait their turn to talk and try not to talk over one another for the clarity of the record. And every now and then I might chime in just for some legal guidance, but we'll start initially with a petitioner's argument and go from there.
All right. Petitioner, please go ahead and stand to the podium. And could you please tell us your name and spell it so we may have it for the record?
My name's Stephen Potts. I'm an attorney. I am not the petitioner. I am the attorney for the petitioners.
Okay.
The two petitioners are Avant-Garde Medical Group LLC and Yland LLC. Avant-Garde Medical Group LLC applied for a certificate of occupancy for the property at 793133 Lincoln. Yland LLC is the owner of the property and the would-be landlord of the tenant. Avant-Garde intends to operate a medical and diagnostic facility on the property in order to certify prospective patients under the Illinois Medical Cannabis Act. So they would be doing diagnostic and medical procedures with patients to determine whether they're eligible to receive cannabis under the Medical Cannabis Act. They would not be a dispensary. It's not a grow facility. It's simply a clinic to certify people under that program. So Avant-Garde applied for a certificate of occupancy, and the zoning administrator on November 17th issued a letter denying that certificate of occupancy. And The issue is under the Skokie zoning ordinance, specifically sections 118251 and 118252. I did bring and submitted to the zoning administrator earlier today a memorandum with legal authorities. And he suggested that I bring that tonight, and I brought 10 copies. So I would like to add that to the record if I may.
We're not going to have the body review case law. They're going to be guided. I'll allow you to give summaries of what the case law stands for, but in terms of them actually being submitted into the record and the panelists actually reviewing the case law itself, I'm not going to allow that. But you and I can both give our legal advice as to what the case law stands for.
Okay. So just for the record, you're denying my request to add this memorandum to the record?
Not the memoranda, just the case law.
Okay, so,
The memoranda and the lease can go into the record,
Okay,
not the case
terrific.
law that you appended.
can I hand that out then?
We already have it.
Okay, have you,
Yes.
everybody has copies then?
Yeah, we did,
Okay.
we did receive electronic version that was forwarded to one of our secretaries, and it was added to the packet.
Okay, terrific.
The March 21st
Right,
memorandum.
you just removed the two reported cases from the back?
They actually still have them. I'm going to advise them not to read them, but they're appended to the packet. They have your entire packet. I'm just going to advise them not to read the case law itself, but you can summarize it if you choose.
Okay, terrific. In a nutshell, our position is that under section 118251 of the Skokie zoning ordinance, this property has been used as a medical and diagnostic clinic continuously from 2006 until the present time. And therefore, this use was grandfathered in when the permitted use of the property was changed from mixed use to a retail street. That's what the designation of the property is now. It's designated as a retail street. And the uses are fairly limited, and use as a medical or diagnostic facility would not be a permitted use. So what we have from the get-go is a legal, non-conforming use under the law. And it's our position that to the extent that the property has never, since 2006, not been used as a medical and diagnostic facility, that we are entitled to continue that legal non-conforming use under both section 251 and 252 of the Skokie zoning ordinance. It is stipulated, I believe, and I'm sure I'll be corrected if this isn't the case, that in 2006, Dr. Diagnostic occupied the premises and received a valid certificate of occupancy from the village of Skokie. So that use was lawfully established. And the property was continuously used by Dr. Diagnostic at least until the end of 2016 and possibly even into 2017, but at least until the end of 2016. Those facts are averred in an affidavit that's part of your packet, an affidavit of Beata Cabani, who is the on-site agent for the owner of the property. In addition, even during the period of time when Dr. Diagnostic operated from the premises, there was a podiatrist, Dr. Yanowski, who came into the building, I'm told as early as 2013, but we've provided you with a copy of a lease that's dated in May of 2016, which is before Dr. Diagnostic ceased operation. So at all times, from 2006 to today, there has been an operating medical diagnostic clinic in that property. It gets a little technical, but under I believe the zoning administrator's position is that because Dr. Diagnostic, which held the certificate of occupancy, ceased operating end of 2016, early 2017, that the property was vacant within the meaning of 118252 of the Skokie zoning ordinance. Therefore, the intended use by Avant-Garde Medical Group is not a permitted use. We believe that that interpretation is incorrect as a matter of law. And I've set these arguments out in writing in the memorandum that you now have. But specifically, we believe the zoning administrator is reading into section 252 a requirement that is not there. And that is that the occupant of the property, no matter the fact that it is continuing the permitted legal non-conforming use, does not have a certificate of occupancy. Therefore, as a matter of law, the zoning administrator takes the position that the property is vacant when it is not vacant and that the use is continuing, and that is a lawful nonconforming use. In addition, there is, under Illinois law, as established by the courts, not only would there have to be an actual abandonment of that prior nonconforming legal use, there has to be events on the part of the owner, an intent to abandon that legal prior nonconforming use. And there certainly is not under the facts here, to the extent that there's still an operating medical diagnostic clinic in the property. So without an intent to abandon under Illinois law, you cannot have a vacancy under the Skokie zoning ordinance. One of the cases that we cited, in fact, the property was completely vacant for a period of time beyond the period of time required to establish a vacancy, because the tenant had been evicted, the property went into foreclosure, and it was completely vacant for longer than, I believe it was 4 months in that case, in the city of Des Plaines case. Despite that, the court said that there was not an intent on the part of the owner to abandon that prior legal nonconforming use and permitted a new tenant to come into the property consistent with the prior legal nonconforming use. And that's all we're asking here. The new tenant that we want to bring in to this property, Avant-Garde, wants to operate a medical diagnostic clinic. The property has always been used in that manner since 2006. And therefore, we believe that the zoning administrator's interpretation was in error and should be reversed. Thanks. I would just say one more thing for the record, which is that I did bring a witness who is Beata Cabani, whose affidavit you already have. I was simply going to have her perhaps add to that. Are you going to let me?
That request is denied. And the basis of that is this, we consider this an appeal and the factual record having been closed prior to today. So we're not going to entertain any testimony or new evidence.
Okay, well, if I may state for the record, that wasn't at all clear to me, that the factual record had been closed. It is clear to me that for purposes of any subsequent judicial proceeding, that the record here will be the record relied upon in any court proceeding, which is why I'm making the proffer today to offer this testimony.
It's been noted.
Thank you. Are there any questions before I take a seat?
We're actually not going to entertain questions of the petitioner. We'll only entertain questions for staff or from Mr. McCarthy.
Okay.
Mr. McCarthy, did you want to go ahead and make your presentation to the board, please?
Thank you very much.
All right. So if you would, state who you are, and so we may have it for the record.
My name is Jim McCarthy. I'm an assistant corporation counsel for the Village of Skokie. I will be presenting the arguments on behalf of the Village of Skokie to this board, asking this board, after hearing all the arguments, to affirm Mr. Augustine's denial of a CO to Dr. Cannabis. And before I start, I just wanted to, at least from the Village of Skokie's position, if you look at the actual village ordinance, it talks about an appeal. This is where we are at now, is an appellate process. Mr. Augustine, as a zoning board official, made a determination, and the ordinance talks about if a petitioner is not happy, they have the right to appeal. So to the extent that this is an appellate procedure, our stance would be that the proofs are closed and that we're only arguing on the brief that petitioner submitted, the response of Mr. Augustine, and then the arguments from both counsel. I do agree with petitioner. The only issue for the board to determine in this case is whether or not there was a discontinuance of a non-conforming structure. And I know initially, if you look through the both Mr. Augustine's staff report, initially when Dr. Diagnostic went in, I believe it was in 2006, it was legally conforming. That changed, though. In 2009, I believe, or 2010, the Village of Skokie changed the ordinance, and at that point, it became a non-conforming legal use. And what we have now is whether Dr. Diagnostic discontinued with their non-conforming use. And in order to determine that, there's really two questions that the board has to decide whether Mr. Augustine made his decision correctly. The first one is, did this certificate of occupancy for Dr. Diagnostic lapse? And if it did lapse, was that lapse greater than 6 continuous months? And based on the evidence that's in the record here, we believe that the answer to both those questions is yes. With respect to the first question, the petitioner admitted in his submission initially to Mr. Augustine that, and he testified here a couple minutes ago, Dr. Diagnostic stopped operating as a clinic sometime at the end of 2016. I think he said maybe into 2017. Just chronologically, they applied for a certificate of occupancy in October. So if you just do the math, January 1, 2017 to October 1, 2017 is longer than 6 continuous months where Dr. Diagnostic has not been operating. So yes, to both those questions. Did the certificate of occupancy lapse? Yes. Was it more than 6 consecutive months? Yes. And then if you look at the village ordinance, which is laid out in Mr. Augustine's memo, referenced by council as well, section 118-252A says any lot or structure, this is critically important, or portion thereof. Now, there's testimony of a podiatrist in the back and maybe somebody who does Medicare in the back, but certainly the portion that's Dr. Diagnostic, by petitioner's own admission, ceased to operate for longer than 6 months. If any portion thereof occupied by a non-conforming use with a valid certificate becomes vacant for a period of 6 consecutive months, must be reoccupied by a conforming use in compliance with this chapter. And the problem with that is their certificate of occupancy is not considered conforming. So that is where Mr. Augustine denied the certificate of occupancy. And if you go down, there's a section 22-278, talks about conditions for issuance renewal. And it says under 22-278A, the village manager or designee, that'd be Mr. Augustine, shall only issue a certificate of occupancy or renewal as required in this article if the following conditions have been satisfied. Number 1, the subject property and premises are in compliance with all applicable codes, ordinances, rules, and regulations of the village. And clearly, having the marijuana distributorship is not in compliance. It's not a valid use pursuant to the ordinances of the Village of Skokie. Based on that, the Village of Skokie believes that Mr. Augustine properly denied the certificate of occupancy. We would ask this board to affirm that his decision was correct. And then lastly, with respect to some of these other issues, and they're mentioned in the staff report, neither the podiatrist nor this Medicare administrator were ever listed on the certificate of occupancy that Dr. Diagnostic had. That's in violation of village code. On top of that, administrative offices aren't permitted in a special use. So again, there's not even this example of we were continuously in use. These two different practices are in violation of the village code. And finally, and it's mentioned in here in Mr. Augustine's report, a lease doesn't constitute use. There was actually some research done by one of the staff members of the village. Nobody can find anything about either Dr. Alexander and this other individual, the Medicare individual, is having an actual location or an office at this place, Dr. Diagnosis in Oakton, or on Lincoln Street. And so, you know, the fact that there's a lease doesn't indicate that anybody's in there, and really there's the burden, their burden of proof that there is someone in there, I think falls short. For all those reasons, the Village of Skokie would respectfully request that this board affirm Mr. Augustine's initial denial and deny the certificate of occupancy to the petitioner. Thank you.
All right, thank you, counsel. Does anybody on the board have any questions for Mr. McCarthy or Mr. Augustine at this point? Because if not, then we can go right into the petitioner's rebuttal. Okay. Yeah, go ahead, Mr. Potts.
First, I want to make something very clear. I think there was a misstatement by counsel. He referred to the prospective tenant as a marijuana distributorship. That is not what this business is. What this business does, it's a medical clinic that certifies people who want to participate in that program. There will be no marijuana sold on the site, just so we're clear on that. This is a medical office. Now, the critical question for the board is the interpretation of section 118-252A of the Skokie zoning ordinance. Council quoted it. It says, any lot or structure or portion thereof occupied by a non-conforming use with a valid certificate of occupancy, comma, which becomes vacant for a period of 6 consecutive months, comma, must be reoccupied by a conforming use in compliance with this chapter. In order for this section to apply, there is a threshold requirement that this property became vacant for a period of 6 consecutive months. That never happened. The only competent evidence you have, which is in the form of Ms. Kabani's affidavit and the Dr. Yanofsky lease, unequivocally, and it's not contradicted, is that the property has been continuously used as a medical clinic from 2006 until the present time. So the property never became vacant for any period of time, much less a period of 6 consecutive months. Without that requirement, this section of the zoning ordinance doesn't apply. The only way it even arguably applies is if you read that requirement to mean that if the occupant, there is one, if the occupant doesn't have a valid certificate of occupancy, then as a matter of law, the property is vacant. In which case, every piece of property in the village of Skokie, to the extent that for commercial purposes or where a certificate of occupancy is required, that does not have a valid certificate of occupancy would be deemed legally vacant. That is really the position that the zoning administrator is taking. And I would submit that that is not what the ordinance says. I would also point out that council did not address the holding of Illinois courts that in addition to an actual vacancy, there's a requirement in order to deprive the owner of this property right, which is to rent the property to a prospective tenant, there has to have been an intent on the owner's part to abandon the prior legal non-conforming use. The law is relatively clear about that. And there's certainly here is no intent on the part of the owner to abandon that prior legal non-conforming use. So again, we would ask that the zoning administrator's decision be reversed. Thank you.
Just very briefly, the Corporation Counsel's Office did review the case law that the Petitioner's Counsel submitted regarding intent, and it was the Corporation Counsel's interpretation that intent is not required per the village ordinances. Also just kind of state as a recap that we are looking to either affirm or reverse Mr. Augustine's decision, and all that we should consider in this matter is what Mr. Augustine considered as well as what's been submitted so far into the record. And I suppose the chair will soon entertain a motion unless anyone has any questions regarding their responsibilities.
Yeah, Commissioner Perlin.
Well, I have a question for Mr. McCarthy for some clarification. These are factual questions. So there's a building, and this building at one time had more than one tenant occupying different parts of the building, a podiatry clinic and this other diagnostic clinic. I'll wait for you to step up to the podium.
According to the affidavit that was submitted by the petitioner, at some point, both a podiatrist and a Medicare administrator were in this office as well, unbeknownst to the Village of Skokie.
Right, so there was no certificate of occupancy issued for those businesses.
That's correct, in violation of village ordinance.
And they occupied obviously a different area than the non-conforming use that was grandfathered.
That's correct.
Okay. Okay, now, are we having a discussion of any type or just questions?
I'll leave that to Corporation Counsel as far as how much latitude we have in the discussion at this point.
I think that it should be primarily limited to questions of staff unless you really think there's something that needs to be discussed in particular before moving forward.
I don't think there's anything that needs to be. We might like to discuss it. It needs to be discussed.
Oh, okay. Yeah, Commissioner Gersner, you have a question for Village Council?
I do. Mr. McCarthy, do you know when that building was sold?
I do not, perhaps Mr. Augustine does. I don't know off
Because-
the top of my head.
Because in my research, that building was up for sale for a while. So,
I do not know when the building was sold or if it has been recently sold. All I know is that on the certificate of occupancy application, the owner of the property is listed as, forgive me about the pronunciation, but the property information, property owner is listed as Najdi, N-A-J-I, Damaj, D-A-M-A-J, I believe it's spelled on the application. That's the only information that was provided on the certificate of occupancy in October, was, I believe, who at that time was the property owner. I haven't done any research on the current ownership.
And I'll just caution, even though we generally love your research in other cases, this is one of the unique situations where we're reviewing Brian's actions as he saw at the time. So we really can only look at what is in the record. So if anyone's done any independent research, you should really put that out of your mind and focus on what's in the record and what informed Brian's decision, not so much what's informed your decision after independent research.
I have a question.
Yeah, Commissioner Kirkpatrick?
So is Skokie's interpretation of vacant a lack of certificate of occupancy?
Well, in this case, citing 118-252A vacancy, any lot or structure or portion thereof occupied by non-conforming use with a valid certificate of occupancy. Dr. Diagnostic clearly had a certificate of occupancy. We've had no information provided to us that they've occupied that portion of the space. Our interpretation is that that portion clearly was vacant, and the new certificate of occupancy was to take over the portion vacated by Dr. Diagnostic.
So just to clarify then, Brian,
I'm
uh,
not done.
what you're saying is your interpretation of this statute would be that if you have a 10-story building and 9 stories are occupied by one tenant and then 1 story is occupied by a different tenant, and they're both the same non-conforming use, if the tenant occupying the 9 stories vacates and those 9 stories are vacant for 6 months, then that would be considered a discontinuance of that use for the 9 stories.
For the space that had a valid certificate of occupancy that vacated the space. The entire building is not vacant,
Right.
but the portion that was used by non-conforming use, that tenant has vacated the premises, and the new certificate of occupancy from my understanding, was to occupy at least most of or all of that space that was vacated.
And the petitioner concedes that that space was empty? Because I'm asking
Well,
from the facts.
right.
Because I did not get that from
Yeah.
from his statement.
Well, and I would just direct you and the rest of the board to the affidavit, which is the petitioner's own admission that, yes, as of the end of 2016, Dr. Diagnostics ceased to operate. And they came in to apply for a new CO in October of 2017. So by their own admission, counsel had said there was no address to the other case law he provided. The petitioner in this circumstance admits that Dr. Diagnostics ceased to operate for more than 6 months in violation of what the village ordinance reads.
My question really was, it was the space vacant?
Yes.
Okay.
Any other questions for council or for staff at all?
And just to be clear, the scope of our decision today deals with the administrative review. It doesn't deal with any other issues of law or fact, whether this would or wouldn't be, with the same type of non-conforming use. Those weren't, that's not under review today.
As I always say in my opening statement, I said the zoning board of appeals is not a court of law. We're not here to adjudicate anything. As corporation counsel has admonished everybody tonight, all we are here solely to do is to render a decision whether or not to uphold the decision of zoning staff if they made the correct and proper decision. So,
I have a question for Brian.
Commissioner Arden.
Thank you. On the certificate of occupancy, the initial certificate of occupancy, does it identify a suite in the building, or does it just provide the address, which would cover the whole building? I see a copy here of the application that was filed in October 2017, but not the initial certificate of occupancy.
For Dr. Diagnostic,
Yes.
we don't have a copy of that.
So,
Dr. Diagnostic's certificate of occupancy did not, to my knowledge, did not specify a suite. So we're given an occupancy for, it was either 7931 or 7933 Lincoln.
okay, well, I would think that if we're, we're looking at it as to the specific space that he occupied in that building, that would be specified in the certificate occupancy if it's a suite or a unit number, else wouldn't it apply to that entire structure?
The new application, my assumption, applied to the entire structure. They never specified we're only taking 75, 85% of the space.
Yeah, no, I'm more confused now, I guess. We don't have a copy of the original certificate of occupancy that we can examine. Because if the original certificate of occupancy just said 7933 North Lincoln Avenue, wouldn't that apply to other tenants inside of that building as well?
Would a certificate of occupancy for Dr. Diagnostic at 7933 apply to other tenants, different businesses?
I mean,
No. In
would,
my opinion, no.
okay.
Well, I think just to comment on this, I think the certificate of occupancy is sort of a red herring in terms of this analysis. It would really be stated on the lease. That's what the person's actually occupying. The certificate of occupancy has no legal bearing on what they're permitted to occupy within a building. It's a form that's filled out that the village does some type of review on, but it's not either limiting or restricting or allowing occupancy of any particular portion of the building. The lease in the building would cover that.
I'm sorry, but that doesn't make any sense to me. Why would you require multiple certificates of occupancy unless you specified what part of the building they were?
But I don't think that's relevant, because it's not a legal document. The lease is a legal document. If somebody leaves off a suite number on a certificate of occupancy, and I'm in one suite in a 12-story building, such as we are in, it doesn't mean that I'm allowed to occupy that whole building. I'm allowed to occupy what my lease says I'm allowed to occupy.
Any other questions for staff or council? Or corporation council for any sort of guidance at all, for that matter? I see where we're trying to go with the certificate of occupancy issue. To me, in layman type terms, I think we're kind of over analyzing this particular issue. So, rather than getting at what it really states in the intention of the law and what has really happened, in fact, via the documentation that's been given to us about how this space was not occupied by Dr. Diagnostic. So
what we're looking at is, did the zoning administrator's decision, was it correct? That's what we're looking at,
right,
period.
That's correct.
nothing more. So that being said, if there's not any more questions, the chair will entertain a motion.
I will move to make a motion that
Commissioner?
the zoning administrator's decision to deny the certificate of occupancy is valid.
Okay,
Mr. Chairman, I'd second that.
okay, Commissioner Salvi. Okay, so the motion is to concur with staff's recommendation to deny the certificate of occupancy.
Correct.
Okay, so we have a motion to concur. It's been seconded by Commissioner Salvi. And the chair will go ahead and take the roll. Commissioner Perlin?
Yes.
Commissioner Franklin?
Aye.
Commissioner Shaw?
Yes.
Commissioner Gersner?
Aye.
Commissioner Jacobson?
Aye.
Commissioner Kirkpatrick?
Aye.
Commissioner Arden?
Aye.
Commissioner Salvi? And the chair will vote aye. So in the matter of 2018-02Z, the appeal has been defeated. The administrator's decision has been upheld by unanimous vote. So Corporation Council, where do we move on from here?
Council, I'll just state that this is considered a final hearing body, so your next remedy at this point would be an action for administrative review in the circuit courts. That's all I have.
Okay. All right. Well, thank you very much. To close our meeting, our normal meeting that would be held on April 4th has been canceled at this particular time. Next regularly scheduled meeting will take place on April 18th, 2018. So that being said, I hope everybody has a good rest of the month of March, and that's it. This meeting of Village of Skokie Zoning Board of Appeals is dismissed. Thank you.